It is a privilege to honor Hal Wooten's life in the law by celebrating those he called the humbler servants of the law, who, in the dark days through which democracies have been traveling, defended the central values of the legal profession, the right of everybody to a fair hearing and a reasoned decision, according to the facts and the law, by an honest and unintimidated judge. You will be more familiar than I with courageous Australian examples, Hal himself, lawyers like Stephen Keim, who represented Dr. Mohammed Hanif, Rob Sterry and Jennifer Robinson, who are acting for Julia Assange, and Michael Morey, now in Aussie, who represented David Hicks. I am going to talk about the American lawyers who have resisted attacks on the rule of law in the years since 9/11. Why do I focus on the rule of law? Surely the Bush administration is guilty of far greater offenses, the Iraq War being the most egregious example. But I am interested in resistance to injustice, and unfortunately, significant American opposition to that war collapsed soon after the March 2003 invasion. Still, you might ask, is the rule of law worth defending? Critical legal studies, which I helped to found in 1977, reiterated what we have long known. Law cannot be separated from politics and is far more likely to reproduce and reinforce power inequalities than to oppose them. And yet, the rule of law embodies fundamental notions of fairness. Those due process guarantees are what allow lawyers to redress other injustices. They have the potential to enlist support across the political spectrum. As a new law graduate in 1965, I saw firsthand what civil rights lawyers were able to achieve in Mississippi. A quarter century later, I was privileged to witness the courage, commitment, and competence and the surprising victories of lawyers in the struggle against apartheid in South Africa. When Abu Ghraib belatedly grabbed my attention in 2004, I knew I had to understand how the American legal system responded to the greatest threat to the rule of law in my adult life. I expected lawyers to be at least as successful as they had been in South Africa. After all, the United States had 2 centuries of experience in conforming executive and legislative actions to a written constitution with a Bill of Rights. Its judiciary was independent, its media free of government control, its legal profession large and diverse, and its NGOs sophisticated and well-resourced. Yet, like many others, I have been deeply disappointed by how little human rights lawyers have been able to achieve in the nearly 13 years of the American war on terror. This is not for want of trying. Organizations like the ACLU, Human Rights First, Human Rights Watch, Amnesty International, the Center for Constitutional Rights, the Open Society Foundation, Reprieve, and others have fought vigorously. Hundreds of lawyers from firms of all sizes, as well as legal aid and public defender offices, have brought habeas corpus petitions on behalf of Guantanamo detainees. Military lawyers from the 4 branches of the armed services, from the judge advocate generals and the staff judge advocates, have challenged the legal framework of the war on terror and aggressively represented accused before military commissions. Today, however, I will not discuss these heroes, although they cannot be honored too much. Instead, I want to explore what it has meant to be a good lawyer in the war on terror by addressing 4 lawyers whose experiences of injustice transformed them into champions of the rule of law. The first is Matthew Diaz. His is a Horatio Alger story with a tragic ending. After his parents went through a bitter divorce when he was 6, Matthew and 3 siblings lived with their mother, moving so often that he had attended 9 schools by the time he was in 7th grade. Then he moved to his father, Robert, a nurse who had remarried and was living the Southern California dream, which I think is rather like the New South Wales dream, a house with a swimming pool and a pair of horses. 2 years later, however, his father was charged with euthanizing 12 elderly patients. Diaz dropped out of school at 16, moved into a motel room with his 28-year-old girlfriend, and washed dishes for a living. Having enlisted in the army as soon as he turned 18, he was in Germany when he learned that his father had been convicted of the 12 murders and sentenced to death. Convinced of his father's innocence, he completed a bachelor's in criminology. Although he planned to leave the military and become a cop, seeing the Jimmy Smith character on LA Law persuaded him to go to law school. He graduated a semester early while driving a mail truck on weekends and then completed a master's in law. He transferred to the Navy, serving in the military for 18 years. Toward the end of his 10 years as a staff judge advocate, he was recommended for early promotion to commander as a consummate naval officer and a stellar leader of unquestionable integrity. He volunteered for a 6-month tour of duty in Guantanamo, arriving in July 2004. At the time, his daughter was 15, close to the age he had been when his father was charged with murder. At Guantanamo, he was quickly outraged by government lies. He felt pity, not fear, for detainees maligned as the worst of the worst. In the wake of Abu Ghraib, the administration constantly protested that we do not torture. You'll remember that phrase. George Bush uttered it ad nauseum. But assigned to investigate abuse allegations, Diaz soon filled 2 large binders, including a senior FBI agent's assertion that the military had ignored valid complaints. Diaz felt a good case could be made for allegations of war crimes. He was ordered to argue to a federal court that the military should be able to eavesdrop when detainees met with their civilian lawyers, even though military intelligence at Guantanamo said that was unnecessary. The Department of Justice prepared an affidavit for the commander asserting that some detainees had been trained to pass coded messages in furtherance of terrorist operations. Diaz was asked to show how 12 Kuwaiti detainees could do so, but he could find only 3 who were even plausibly dangerous. He saw the argument as a reach. We were just throwing up obstacles in the way of implementing the Supreme Court's decision a week before he had arrived that detainees were entitled to petition for habeas corpus. He was copied on a letter from the Secretary of the Navy refusing to disclose detainees' names to Barbara Olshansky, a lawyer at the Center for Constitutional Rights. And without those names, there was no way that CCR would be able to provide legal counsel because they couldn't file petitions. Diaz was convinced that no matter what the court said, the military would just keep stonewalling. Working late on January 2nd, 2005, he found a list of names and nationalities of all 551 detainees, with codes indicating who had been interrogated and the value of the information elicited. The list was not marked secret. He said, "I knew if I didn't do anything, nobody else was going to." He printed the list, cut it into 39 sheets to fit into an envelope with a Valentine's Day card, and mailed it to Barbara Olshansky at CCR in an unmarked envelope on his last day in Guantanamo. Olshansky agonized for weeks about what to do and ultimately called the chambers of the federal judge with whom she had filed the habeas petition and was told by the clerk to give the envelope to the FBI. Diaz was quickly identified by his fingerprints, and his computer hard drive indeed contained the incriminating list. By the time he was court-martialed, however, the government had released all of that information in response to an Associated Press Freedom of Information Act lawsuit. Diaz said, "My oath as a commissioned officer is to the Constitution of the United States. I'm not a criminal. I made a stupid decision, I know, but I felt it was the right decision, the moral decision, the decision that was required by international law." He realized he should have raised the issue up the chain of command, but nothing I said would ever have left Guantanamo. After a week-long trial, he was acquitted of printing out national defense information with intent or reason to believe it would be used against the United States, but he was convicted of knowingly communicating information to a person not entitled to receive it. Although he faced up to 14 years, he was sentenced to 6 months and discharged from the military. After being released, he visited his father on death row and explained what had happened. His father, Robert, said proudly that Matthew had done the right thing, but the Kansas Supreme Court disbarred him against the recommendation of its disciplinary committee, ending his legal career. I should add, by the way, that as is typically the case, His father died of natural causes on death row. California has not actually executed anybody in many years. My second lawyer is Stephen Abraham, a conservative Republican who cried when Richard Nixon resigned. As the son of a Holocaust survivor who emigrated to the United States after World War II, Abraham felt an obligation to repay his country for the opportunities it had given his family. He spent 26 years as an Army Reserve intelligence officer, rising to lieutenant colonel and being decorated twice. In September 2004, he also jumped at the fantastic opportunity of a 6-month tour of duty at Guantanamo in something called the Office for the Administrative Review of the Detention of Enemy Combatants. He helped to build the evidentiary database for the combatant status review tribunals, the so-called CSRTs, which determined whether detainees could be held. And he sat on one of those tribunals for one detainee, Ahmed al-Khizawi. Abraham quickly became skeptical of the claim that all detainees were jihadists. As an intel agent, I would have written junk statement across that. Anything that resulted in a not enemy combatant finding would just send ripples through the entire process. The interpretation is, you got the wrong result, do it again. The hearings amounted to a superficial summary of information, the quality of which would not have withstood scrutiny in any serious law enforcement or intelligence investigation. As a lawyer, he began to feel he should not be involved. There were too many assumptions, too many presumptions. He wrote to his superior, Rear Admiral Magara, on December 10th, asking to be relieved because my participation may be in conflict with my obligations as an attorney, but he got no reply. After his tour ended, he returned to his 2-person commercial practice in Newport Beach, California. But during visits to Washington, he stayed with his sister, a lawyer, whose colleagues had been representing Guantanamo detainees. In June 2007, after she related his concerns to those colleagues, one of them, Matthew McLean, asked Abraham to look at Magara's affidavit in opposition to a habeas petition. Outraged by what he saw, Abraham wrote his own declaration. I communicated to Rear Admiral Magara the fundamental limitations imposed upon my review of the organization's files and my inability to state conclusively that no exculpatory information existed related to the CSRT subjects. It is well known by the officers in my office that any time a CSRT panel determined that the detainee was not properly classified as an enemy combatant, the panel members would have to explain their findings to the deputy director. There would be intensive scrutiny of the findings by Rear Admiral Magara, who would in turn have to explain the finding to his superiors, including the Undersecretary of the Navy. In the CSRT on which Abraham had served, all of us unanimously found the information presented to lack substance. We determined that there was no factual basis for concluding that the individual should be classified as an enemy combatant. Rear Admiral Magara and the deputy director immediately questioned the validity of our findings. They directed us to write out the specific questions that we had raised concerning the evidence to allow the recorder an opportunity to provide further responses. We were then ordered to reopen the hearing to allow the recorder to present further argument. Ultimately, in the absence of any substantive response to the questions and no basis for concluding that additional information would be forthcoming, we did not change our determination. In each of the meetings that I attended following a finding of not enemy combatant, the focus of inquiry on the part of the leadership was what went wrong. I was never assigned to another CSRT panel. The detainee, al-Khizawi, had hepatitis B and tuberculosis. He had not seen or talked to his family for almost 6 years and was rapidly losing his mind as he sat in total isolation. Abraham said, he was about my age and he has a daughter, as did Abraham. He hasn't seen her in a long time. He's close to death. 2 weeks after McLean filed Abraham's declaration, the U.S. Supreme Court agreed to hear the appeal in Boumediene, which ultimately reaffirmed the right to habeas. The habeas lawyers subsequently learned that 2 months after Abraham's CSRT, the one on which he sat and which unanimously found that Ghazawi was not an enemy combatant. The Defense Department rejected the finding, resubmitted it to another CSRT, which unanimously found the opposite. Abraham said, conducting new CSRTs, even discussing the possibility, repudiates every prior assertion that the original CSRTs were valid acts. They are, in essence, both a hypocritical act as well as an act of moral cowardice. The CSRTs were specifically designed to reach a result, and in the few instances where a contrary result was reached, pressure was exerted to change the decision, a new tribunal was selected, or the decision was simply disregarded. An Army major who had sat on 49 tribunals also submitted an affidavit criticizing them. After Abraham testified before the House Armed Services Committee that the evidence before the CSRTs was garbage, McGarrett told the committee that Abraham only saw a very narrow piece of the process. Perhaps. But of the 578 CSRTs, 539 of them found detainees to be enemy combatants. That's a conviction record, if you like, of 93%. Nevertheless, virtually all of them have since been released. These were the worst of the worst. President Obama replaced the CSRTs with something called the periodic review boards, which do in fact offer more due process, and 2 of them have now reached conclusions, one finding not an enemy combatant and the other finding an enemy combatant. We'll have to wait to see how the rest of them perform. 2 military lawyers were deeply affected by participating in military commissions. So far I've talked about the attempt to obstruct the habeas corpus petitions, and then the review process trying to group detainees into one category or another, enemy combatants or not enemy combatants. But a small number of detainees were put before military commissions, and now that's what I'm going to talk about. William Kubler, one of these lawyers, married the first girl he dated in high school, always voted Republican, and practiced business law in San Diego, another Californian. In his late 20s, however, his mother's death prompted him to become a born-again Christian and join the Navy. His sister said he realized there's more to life than driving a BMW and having your initials on your cuff. Don't look at your cuffs. In 2007, he was appointed to represent Omar Khadr, a Canadian accused of killing an American, Sergeant Speer, with a hand grenade when Khadr had been a juvenile. Dennis Edney, the Khadr family's Canadian lawyer, complained that Kubler has no trial experience, no criminal or terrorism law experience. He was just a tax lawyer. But Kubler enthusiastically embraced his new role. He criticized the District of Columbia Circuit Court's refusal to stay the proceedings despite significant doubts as to the commission's legality. At the first hearing, he accused the prosecution of having concealed for 5 years, an eyewitness it had identified soon after the initial firefight. They weren't going to tell us who he was or how to get in touch with him or where he was. This is a process that's not designed to be fair. It's designed to produce convictions. Affidavits by Pakistani bounty hunters were classified secret. The prosecution was exerting enormous political pressure to get these trials moving, practically pounding on the table. He challenged the judge, Colonel Brownback, who had barred the defense from contesting the constitutionality of the military commission at this stage. In a closed-door meeting, Brownback said he had taken a lot of heat for ruling earlier that the commissions were illegitimate over objections by the Defense Department and the White House. Brownback was angry with Kubler for disclosing that conversation. When it emerged that Brownback had secretly ordered the defense not to reveal the names of any prosecution witnesses, Kubler objected. Instead of a presumption of innocence and a public trial, we start with a presumption of guilt and a secret trial. He had earlier told the judge and prosecution that the manner in which this is being dealt with, that is off the record via email, creates an added level of difficulty by making it appear that the government is trying to keep the secrecy of the proceedings a secret itself. In February 2008, Kubler revealed that the military knew that another enemy fighter had been alive when Speer died and might have thrown the grenade. The next month, Kubler added that an American commander reported that Speer's assailant had been killed, unlike Khader, who was still alive. In April, Kubler urged Canadians to pressure their government to ask that Khader be returned to Canada for trial. I don't believe anyone can get an acquittal at Guantanamo Bay. Some eyewitnesses said Speer might have been killed by friendly fire. The prosecution originally claimed that Khader was the only fighter alive when Speer's unit stormed the compound and there had only been one grenade blast. But a report made available to defense counsel only recently disclosed that forces continued to throw grenades during the chaotic final confrontation. Denouncing these inconsistent and contradictory accounts, Kubler accused the prosecution of trying to rush the case to trial because its mythical assessment of events was rapidly falling apart. He had just learned from a Canadian diplomat about another report, which the prosecution previously claimed had gone missing, and asked Brownback to order its production. In April, Kubler testified to a Canadian House of Commons subcommittee on international human rights that lies have been told about Omar. Justice will not result from a military commission that cannot try U.S. citizens and treats a Canadian as worth less than an American. Bring this young man home to face due process under a legitimate system. The prosecution retorted that the time the defense has spent lobbying the Canadian Parliament would be better spent interviewing witnesses. And many of you will remember that that is exactly the charge that was leveled at Michael Morey in the defense of David Hicks when he came to Australia 7 times. At the end of May, the convening authority abruptly substituted Colonel Parrish for Brownback, whose return to retirement was a mutual decision. Defense lawyers attributed the action to Brownback's anger at the prosecution's failure to produce exculpatory evidence and his threat to halt the proceedings if this were not done promptly. Brownback complained of having been badgered and beaten and bruised by the chief military prosecutor who wanted to accelerate the trial. Kubler called the replacement very odd. The judge who was frustrating the government's forward progress in the Khader case is suddenly gone. The prosecution denied having anything to do with a new judge being assigned to the case. In June, Kubler denounced military commissions as designed to get criminal convictions with no real evidence. Prosecutors launder evidence derived from torture. You put the whole package together and it stinks. Guantanamo's Standard Operating Procedures Manual advised, this is in writing, that because the mission has legal and political issues that may lead to interrogators being called to testify, keeping the number of documents with interrogation information to a minimum can minimize certain legal issues. That almost sounds like the destruction of evidence. Kubler feared that if handwritten notes were destroyed in accordance with the standard operating procedure, the government intentionally deprived Omar's lawyers of key evidence with which to challenge the reliability of his statements. The new chief prosecutor, Colonel Morris, accused Kubler of having habitually flouted the rules and greatly distorting and fabricating information. A Navy spokesman said lawyers had an obligation to defend, but it is disappointing that when counsel do not live up to these professional standards. Kubler replied that serving as defense counsel was a powerful way to witness for Christ by demonstrating your capacity to not judge the way everybody else is judging and to serve unconditionally. In July, Kubler obtained a secret Canadian intelligence report on a visit to Khader in 2004, in which Canadian lawyers had persuaded a Canadian court to order released. It described the notorious frequent flyer program. In order to make Khader more amenable and willing to talk, he was moved to a new cell every 3 hours for a period of 3 weeks. So for 3 weeks, he never got more than 3 hours of uninterrupted sleep. Other abusive treatment reduced him to tears. The prosecution tried to get the report back, prompting Kubler to seek a judicial investigation into its behavior. Colonel Parrish reprimanded the prosecution, he's the judge, reprimanded the prosecution for the time it had taken to decide whether another report could be given to the defense and imposed a deadline. The prosecution objected to Kubler's request that 2 independent psychiatrists examine Khader and testify about his alleged confession. During argument over postponing the trial for the psychiatric examination, it emerged the prosecution had given the defense incomplete medical records. Parrish demanded an explanation, warning the prosecution that when someone decides to violate a court order, those decisions have consequences. In April 2009, the chief defense counsel fired Kubler for unnamed ethical violations. 4 days later, Colonel Parrish, the military commission judge, reinstated him, declaring that he, Parrish, had to approve any firing, which could only be for cause. Kubler said the chief defense counsel had a conflict of interest because he wanted to ensure that his office would continue to represent detainees tried in civilian courts. Kubler wanted to argue to the new administration's review team that Khader should be repatriated to Canada. But a few months later, Khader fired all of his lawyers. A year later, he pleaded guilty in a deal which carried an 8-year sentence, but it also had a requirement that he be transferred to Canada, which has since been done, and he is now eligible to parole. So it's now a question for Canadian politics. My last example is Daryl Vandeveld. Vandeveld was a devout Catholic, the father of 4, a senior deputy state attorney general in Pennsylvania, in charge of consumer protection. Any acquaintance, he said, will probably tell you that I've been a conformist my entire life. As a reservist, he was called to active duty after 9/11, serving as a military lawyer for 7 years in Bosnia, the Horn of Africa, Afghanistan, and Iraq, and rising to lieutenant colonel. In June 2006, his commanding officer praised the absolutely outstanding first-class performance by an extraordinarily gifted, intelligent, knowledgeable, and experienced judge advocate whose potential is utterly unlimited. One of the JAG Corps' best and brightest, saved the toughest jobs in the Corps for him. And as you'll see, they did just that. In May 2007, he was sent to Guantanamo and assigned to prosecute 7 detainees, including Mohammed Jawad, who had been a juvenile when he allegedly threw a grenade in an Afghan bazaar in December 2002, wounding 2 American soldiers and their Afghan interpreter. Vandeveld initially disparaged all allegations of prisoner abuse as embellishment and exaggeration. He dismissed a defendant's idiotic challenge to the legitimacy of commissions. He believed Jawad was a war criminal taught by Al-Qaeda, an Al-Qaeda affiliate, to kill Americans, and claim, if caught, that he was a juvenile and had been tortured. But Vandeveld began developing doubts. He kept finding sources of information and documents confirming that Jawad had been underage and drugged before the alleged attack, and had been abused during interrogation. But he encountered obstacles in releasing those to the defense. Major Fracht, Jawad's military defense lawyer, gave Vandeveld records showing that in mid-2003, Jawad had been removed from the Pashto-speaking wing, he spoke only Pashto, isolated and deprived of books and mail. In September 2003, interrogators observed him speaking to posters on the wall. That Christmas, he tried to commit suicide by banging his head against the metal bars of his cell. Like Khader, he also was subjected to a frequent flyer program. He was moved 112 times in 2 weeks, more than once every 3 hours, and even faster between midnight and 2 a.m. Vandeveld responded to this knowledge by seeking to negotiate a minimal sentence and rehabilitation before Jawad returned to Afghanistan. On May 22nd, he wrote to the defense lawyer Fracht, "If I ever thought this job required me to do anything I considered unethical, I'd be out the door." Fracht answered, "I appreciate that, and I believe you. You may have to take back your comments about Jawad's complaints being embellished and exaggerated. It looks like he was telling the truth. Did you notice that?" I did notice that saddening episode, which is one of the reasons I am pushing for a plea in this case and why I wanted to get this information in your hands as soon as possible. Later that day, he wrote, "By the way, I will correct my misstatements on the record the next time we're in session. I know I am obliged to do that." Soon thereafter, Fracht, the defense lawyer, moved to dismiss the charges for outrageous government misconduct, citing Jawad's torture. Vandeveld responded that Jawad's abuse should only mitigate punishment. So he had moved, but he had only moved part way. Nevertheless, superiors were furious at this admission, reprimanding Vandeveld and making him withdraw it and resubmit a motion declaring that Jawad suffered no ill effects from his alleged sleep deprivation. But the following summer, Vandeveld's doubts had increased. Photos of Jawad's initial arrest showed a naked, terrified boy being strip-searched. In July, Vandeveld chanced to see a report on a colleague's desk about the death of another man detained by the US in Afghanistan. Investigators then had taken a statement from Jawad, who said that at Bagram, the American prison in Afghanistan, he had been shackled, forced to stand, beaten if he tried to sit, and made to wear a black bag over his head. Vandeveld later said this changed him from true believer to truly deceived. He told Fract he was disturbed about the abuse and the absence of any system to provide such evidence to the defense. In August, Vandeveld emailed a Father John Deere, a well-known Jesuit peace activist. I am beginning to have grave misgivings about what I am doing and what we are doing as a country. I no longer want to participate in the system, but I lack the courage to quit. I am married with children, and not only will they suffer, I'll lose a lot of friends. Father Deere replied, God does not want you to participate in any injustice, and Gitmo is so bad, I hope and pray you will quietly, peacefully, prayerfully, just resign and start your life over. This might save lives and change the direction of the entire policy. 2 days later, Vandeveld asked Fract, how do I get myself out of this office? He was seeking a practical way of extricating myself from this mess. By late August, he told Fract there were other disquieting things about Guantanamo, but his superiors would not let him address them or quietly transfer out. Fract replied, now might be a good time to take a courageous stand and expose some of the disquieting things that you alluded to. Fract expected a change in government after the this is the November 2008 election. It wouldn't be a bad idea to distance yourself from a process that has become largely discredited, or at least distinguish yourself as one of the good guys, an ethical prosecutor trying to do the right thing. He suggested that Vandeveld tell the convening authority about his efforts to reach a plea bargain. Vandeveld replied, let me think about that some more. I have to consider the impact on my family. In mid-September, however, Vandeveld resigned, asking to serve the rest of his reserve duty in Afghanistan. He said, I didn't express my concerns to my superiors before asking to be reassigned, largely because I knew both of them are highly indoctrinated ideologues whose likely response would have been to have my security clearance revoked as a punitive and preventative measure. This concern is not happenstance. I could give examples where I'm not bound by my clearance itself. The hostile, dismissive way I've seen another concerned officer treated by superiors was enough for me to conclude my reservations would not be well met. He expected retribution for cooperating with the defense, noting that an officer who had done so got a mediocre officer evaluation report. In a 4-page declaration filed with the Military Commission, he complained that potentially exculpatory evidence has not been provided. I've been accused of forming an attorney-client relationship with a defense attorney, Major Fract, but he and I have developed a cordial relationship of mutual respect, nothing more. I have divulged to Major Fract those items of discovery that, in my professional judgment, the rules for professional conduct, the Military Commissions Act, and the Manual for Military Commissions have required me to relinquish, consistent with my ethical obligations as a prosecutor. I have observed that a number of defense requests, which I considered to be reasonable and in some cases indicated support for, were nevertheless rejected by the convening authority, presumably on the advice of its legal advisor. My ethical qualms about continuing to serve as a prosecutor relate primarily to the procedures for affording defense counsel discovery. I am highly concerned, to the point that I believe I can no longer serve as a prosecutor at the commissions, about the slipshod, uncertain procedure for affording defense counsel discovery. One would have thought, after 6 years of the commissions, that a functioning law office would have been set up and procedures and policies not only put into effect, but refined. In my view, evidence we have an obligation as prosecutors and officers of the court has not been made available to the defense. I have decided to come forward at this point and share some of my reasons for offering my resignation because I believe I have an obligation to provide truthful information to the court, regardless of which side calls me as a witness. He thought Jawad might have been duped into joining an opposition that had previously been allied with the United States. It seems plausible to me that Jawad may have been drugged before the alleged attack. The Afghan Interior Ministry said 2 other men confessed to the alleged crime. Vandeveld was also troubled by Jawad's treatment in custody and had given Defense Department documents indicating sleep deprivation. As a juvenile at the time of his capture, Jawad should have been segregated from the rest of the adult detainees and some serious attempt made to rehabilitate him. I am bothered by the fact that this was not done. I am a resolute Catholic and take as an article of faith that justice is defined as reparative and restorative, and that Christ's most radical pronouncement, command if you will, is to love one's enemies. The chief prosecutor countered that Vandeveld said he was quitting for personal reasons. He was just a disgruntled prosecutor, disappointed that his superiors did not agree with his recommendations in the case. There are no grounds for his ethical qualms. We are the most scrupulous organization you can imagine in terms of disclosure to the defense. When in doubt, we disclose every scrap of paper and piece of evidence. He refused to say whether his office had rejected a plea deal. The Defense Department then did in fact take revenge on Vandeveld, ordering him to get a psychiatric examination, which cleared him to remain on active duty. Vandeveld emailed Father Dear. The reaction was the expected outrage and condemnation. I have and will maintain my equanimity, and while scared for me and my family, know that Christ will watch over me. Called as a witness for Jawad, Vandeveld dropped his initial request for immunity. When the prosecutor's office prevented him from traveling to Guantanamo, he testified by video that military commissions are not served by having someone who may be innocent convicted of the crime. My views changed. I am a father, and it's not an exercise in self-pity to ask oneself how you would feel if your own son were treated in this fashion. I think it is impossible for anyone in good conscience to stand up and say he or she is provided all the discovery in this case. The chief prosecutor retorted that Vandeveld had never once raised substantive concerns. These unfair allegations were a broad blast at some very ethical and hardworking people whose performances are being smudged groundlessly. The prosecution complied beyond what the rules require. The ideal of holding out the specter of wrongful conviction is outrageous. It is because of the nature of this war that there are so many elements fighting in it. Information does not come in a tidy package. But Vandeveld named Defense Department reports not disclosed to defense lawyers, some suggesting that another suspect had confessed to the alleged crime. The judge, Colonel Henley, ordered the prosecution to deliver these. Fract again moved to dismiss, alleging gross government misconduct. Before being reminded that he could not talk to the press until being released from active duty, Vandeveld vowed in an email to do so after he was released. I don't know how else the creeping rot of the commissions and the politics that fostered and continue to surround them could be exposed to the curative powers of sunlight. I care not for myself. Our enemies deserve nothing less than we would expect from them were the situation is reversed. More than anything else, I hope we can recover some of our American values. The prosecution dismissed without prejudice the charges against 5 detainees Vandeveld had prosecuted. The chief prosecutor denied this had anything to do with Vandeveld, claiming that new evidence required a reanalysis of the cases to draft the best possible charges. But Clive Stafford Smith, who represented a detainee whose case was dismissed, said Vandeveld was willing to testify for us if subpoenaed. They want new prosecutors to review the case before refiling charges so they can argue that Vandeveld is irrelevant. At the end of October, Colonel Henley excluded Jawad's initial confession, the one that he had made in Bagram after the abuse. Because the prosecution had not timely disclosed evidence, he accepted the claim that Jawad had been drugged before the attack and he and his family threatened with death if he did not confess. Vandeveld said this eviscerated the government's case. Jawad's other incriminating statements were clearly tainted by mistreatment. Vandeveld expected to be called by the defense in other cases. The commissions are in such disarray and continue to be in chaos. A month later, the judge, Colonel Henley, excluded Jawad's second confession because the effect of the death threats which produced the accused's first confession had not dissipated by the time of the second confession. Vandeveld declared, "It's not the death knell of the case, it buries the case." In 2009, he filed a declaration in support of Jawad's habeas petition. So now there were no military commissions pending against him, and he was seeking habeas. He said in that filing, "It is my opinion, based on my extensive knowledge of the case, there is no credible evidence or legal basis to justify Mr. Jawad's detention." Afghan police had made Jawad place his thumbprint on a statement in Farsi, but Jawad did not speak Farsi and, in fact, was functionally illiterate. Although American interrogators videotaped the statement by Jawad, Vandeveld was never able to get the videotape. The complete lack of organization in the prosecutor's office affected nearly every case. It was like a stash of documents found in a village in a raid and just put on a plane to the United States. Evidence was scattered throughout databases, in desk drawers, vaguely labeled containers, or simply piled on tops of desks. Most physical evidence that had been collected had either disappeared or been lost. As recently as June 2008, Jawad had been beaten, kicked, and pepper sprayed while on the ground with his feet and hands in shackles for allegedly not complying with guards' instructions. The government was still using the confessions Colonel Henley had excluded as coerced, using them in the habeas petition. The chief prosecutor said he would be happy to respond under oath to any of those allegations. He claimed that Vandeveld was disappointed when I did not choose him to become a team leader, and he asked to resign shortly thereafter, never having raised an ethical concern during the 9 months I supervised him. I relied on his reports to me about Jawad and other cases I entrusted to him. Vandeveld retorted, "I wouldn't believe a word the prosecutor says." A few days later, Vandeveld published a Washington Post op-ed in which he continued along the same vein, and for reasons of time, I'm not going to read you the op-ed. But I'll tell you what happened in the habeas petition. U.S. District Judge Huvel ruled in Jawad's habeas petition in July that his confessions were coerced and inadmissible, and she gave the government a week to produce another justification for detaining him. At the end of the week, the Justice Department acknowledged it had no other evidence, but it claimed it was thinking now of prosecuting him in criminal court in the United States. Judge Huvel said, "You have 24 hours to produce evidence that might be admissible in civilian court." The government did nothing, and she granted Jawad's habeas petition, and a month later, he returned to Afghanistan and his family. So now let me try to sum up the lessons the lessons from the War of Terror that I think might be drawn from these 4 stories. Susan Sontag declared that at the center of our moral life and our moral imagination are the great models of resistance, the great stories of those who have said no. But the lesser stories are equally important. Dissidents like Herman Melville's Bartleby the Scrivener, who respond to orders that violate their ethical ideals by saying, "I would prefer not to." The few human rights lawyers who nobly devote their lives to defending the rule of law deserve our profound gratitude and respect. But the rule of law can only survive if ordinary lawyers also do the right thing. The 4 I have described above sought to preserve the integrity of the legal process: CSRTs that purported to identify enemy combatants, military commissions that tried them for war crimes, and habeas corpus petitions seeking their release from Guantanamo. Little in the past of these 4 men predicted that behavior. All were staunch patriots. Abraham felt a special loyalty to the country that had defeated Nazi Germany and opened its doors to his parents after they had survived the Holocaust. All were career military officers, either on active duty or in the reserves, who consistently received superb performance reviews, earning repeated promotions and medals. The military had offered Matthew Diaz an extraordinary ladder for upward mobility. None of them was a rebel. This was the first act of disobedience in a lifetime of conformity for both Abraham and Vandeveld. all believed deeply in the military law they practiced. But some of the four may have been predisposed to resist. Kubler and Vandeveld were deeply religious. Robert Diaz's murder conviction imbued his son Matthew with a strong sense of injustice, and Abraham had been raised with memories of the Holocaust. What seems to have moved them to resist was the contrast between the due process they had come to take for granted in their military and civilian legal practices and the egregious violations they confronted at Guantanamo: failure to disclose exculpatory evidence, pressure to try cases prematurely, selection of cases for political reasons, unnecessary secrecy, abuse of detainees, coercive interrogation, sometimes crossing the line into torture, contempt for international law, and disregard for the Constitution. Some government policies were difficult or impossible to justify, concealing the identity of detainees so no one could file a habeas petition for them. Spying on detainee communications with their lawyers. Some political interference was brazen, assuring prosecutors that they didn't have to worry about the outcome of cases. There would be no acquittals in military commissions. Packing CSRTs with compliant members and redoing the few that found detainees not to be enemy combatants. Replacing military commission judges mid-trial for requiring prosecutors to disclose exculpatory evidence or being too deliberative. Abraham was troubled by his own office's sloppiness and casual disregard for evidence and procedure. The lawyer's outrage intensified when the military lied, insisting that these detainees were the worst of the worst. All were committed jihadists. The U.S. did not torture, or when it sought to cover up its actions. As professionals, lawyers live a unique dilemma. As hired guns, they must assert the truths of empirical and moral claims they do not believe. These lawyers eventually balked, declaring with Galileo, and yet it moves. Some developed sympathy for particular detainees, especially the juveniles Khadr and Jawad, who exhibited psychotic symptoms of torture victims, as well as respect for opposing counsel. Vandeveld wondered how he would feel were his son treated like Jawad. Abraham was moved by the fact that al-Khizawi had a daughter the same age as his own. All of them found resistance difficult. Most needed a long time to form the necessary resolve and act on it. They had to reject firmly held beliefs and relinquish long, rewarding military careers. Vandeveld switched from a true believer to truly deceived. Although some reported up the chain of command, all ultimately concluded that this would be fruitless. Vandeveld feared the consequences for his family. Even though he must have anticipated Father Deer's advice, he delayed following it. He persisted in arguing that Jawad's abuse should affect only punishment, not conviction. In retrospect, Diaz felt his actions had been stupid. Only Abraham seemed to have had few regrets about returning to civilian life. Like Chelsea Manning, Edward Snowden, and other whistleblowers, these men had good reason to be apprehensive. No good deed goes unpunished. Instead of honoring their courage and fidelity to the rule of law, the military first sought to discourage their resistance and, when that failed, cynically impugn their motives. The military insisted Vandeveld's reasons were personal and subjected him to a psychiatric examination. The military never admitted error. It continued to maintain that the prosecution disclosed all evidence when this was patently false. Even Attorney General Eric Holder contemplated a criminal prosecution of Jawad after his military commission trial collapsed, but wisely backed off. When these lawyers persisted in exposing misconduct by the military, it retaliated. Diaz saw his military career end, served time in the brig, and lost his license to practice law. Vandeveld was temporarily muzzled. Once these lawyers defied their superiors, the rupture tended to be complete, partly because of government retaliation. Vandeveld submitted declarations for other detainees, testified before Congress, and wrote in the media. Kubler followed Michael Morey's advocacy for David Hicks in Australia by campaigning in Canada for Omar Khatter's repatriation. Like ripples from a rock thrown into a pool, ripple blowing had further ramifications, some quite surprising. Earlier prosecutors who objected to procedural irregularities were quietly transferred to other jobs. But these more public challenges led a judge to suspend a case and direct the convening authority to remove the legal advisor. In the subsequent trial, the accused was acquitted of some charges and sent home after serving a short additional sentence. Lawyers for 5 high-value detainees then made similar arguments against the legal advisor, who was reassigned to other tasks. Vandeveld's complaints convinced judges that the prosecution was withholding exculpatory evidence. Judge Parrish reinstated Kubler when the chief defense counsel fired him. Vandeveld succeeded in excluding both of Jawad's confessions, not just in the military commissions, but also in the district court, which granted the habeas petition, leading to his transfer home and release. And Vandeveld's resignation forced the prosecution temporarily to withdraw all charges in the other cases in which he had been involved. Khatter's plea deal allowed him to be transferred to Canada, where he would soon be eligible for release. These 4 men demonstrate the enormous power of just saying no. I hope their stories will inspire other lawyers to fidelity to the rule of law, not just at moments of heroic resistance, but in their daily practice. Thank you.